CRJ 225, this is your section of the course where we get into the things as promised. Homicide, assault, and battery is what we intend to cover in this section of the course. For those of you who had introduction to criminal justice at some point, you probably talked about the wedding cake view of crimes. And I've mentioned a few times, some comments related to that. The fact that in the grand scheme of all things that a police officer does in general, a typical police officer, dealing with these things, with homicide in particular, homicide would be on that top layer of the wedding cake. So if you've been to a wedding, if you can picture a wedding cake, some of you have been married, and most of you have been to a wedding. A lot of times a wedding cake has the lower part of the cake that's a bigger part of the cake, and then it has a smaller, or maybe a couple different smaller sections, and there's this one little small section at the top. Typically, I don't know why, but people freeze it and eat it a year later or something. Whatever. But the reason the wedding cake analogy is used is because homicide, assault and battery, those kind of crimes against people and heinous crimes end up being that small portion of a wedding cake. We don't deal with these things as much as we deal with the petty offenses, the misdemeanors, that make up that lower level of the cake, the larger level of the wedding cake. That's usually the level that they give to the guests, right? It's the level that people are out there slicing up and passing out. In this section of the course, we're going to talk about homicide, assault, and battery. We're going to do that in two parts. You'll have part of an assignment regarding homicide and part of an assignment regarding assault and battery. Assault and battery we've already talked about a little bit earlier in the semester as an example when we started to break down or introduce intent and elements of crime and the differences. And I think I mentioned, assault and battery, burglary, robbery. It's important to know those elements, the distinctions, and especially so if you're going to be put in a position in which you are expected to send somebody, for my 911 people in the course, to a particular crime or incident, or if you're going to it. It can be the difference between lights and sirens and putting yourself or someone else in danger because you're going at a high rate of speed, lights and sirens, or it can be getting there in a safer manner. This is also the portion of the course where I ask you to start finding your own cases. Now, typically, you take this course before you take CRJ 227, Administration of Justice, or CRJ 230, the Criminal Procedure and Evidence course. I call it evidence because it's primarily focused on evidence and the procedures that are related to evidence in the law. But you typically take this course prior to those courses. If you've already had one of those courses or in one of those courses now, you are ahead of the game. If you have not, you're going to need to do some work. The resources are within Blackboard. 20 years of using Blackboard, I still refer to our learning management system as Blackboard. Canvas, under modules. So go to modules and you'll find the document. I post the name of the document in the assignment. But you're going to have to start getting familiar with going into Lexis and finding Illinois criminal cases. No other kind of case, Illinois criminal cases. And you're going to use that for the next 5 sections or through the end of the course. And you're going to develop that skill. It's an important skill to have because it allows you to go out and find case law. Case law explains how the law is applied, and we know that, right? The elements tell us what a crime is, the statutes tell us what a crime is, but whether that crime, under certain circumstances actually a crime, well, that's the case law. And we go back to what we discussed the past week, or a couple weeks with the fences. We've seen that, right? We've seen it in the first 3 sections of the course. Cases tell us how the statutes apply to different factual situations or what we can expect in the law. And that's good for you to know and good for you to be able to access and good for you to be able to process in all aspects of your careers, whatever your career path takes. It's good skills to have. You're going to come across, at the very least, questions in your mind about certain developments in the law. And if you think about it, those things come up all the time, right? Changes in public policy, changes in society, things that happen on the news, things that you read about as having been committed as crimes. You can go and look those up. Appeals where convictions have been overturned, you name it. For some of you, it's going to directly affect your daily lives, your daily existence in law and justice. So great skills to have. It's also a skill that you're going to need for CRJ 227 and 230 when you get to those courses. So we're going to start doing that this week with finding a homicide case. Now, I provided a document that breaks down the offenses that we're going to cover this week. And hopefully you've read that document and you've gone to the statutes and read the statutes. If you haven't done that, stop and go do that. And then come back. But I'm going to talk first about homicide. The Illinois homicide statutes break killing another human being into 5 different offenses. And since you found the statute, and I asked you to use the link under modules and just page down once it opens up the statutes, criminal statutes, and you go and find homicide. You found that at 720 ILCS 5/9. And it told you that there is an offense titled first-degree murder, and the essence of first-degree murder is an intentional killing or knowingly performing an act that leads to the death, if the death was not completely intended. It's an intentional killing or knowingly performing an act that leads to death, even if the death itself was not completely intended. And again, the cases are going to give us all sorts of scenarios and factual situations and applications of that statute to those factual situations to describe or to define what is or isn't first-degree murder. The next one is felony murder. A death that occurs during the commission of a felony offense is referred to as felony murder in Illinois. Now, felony murder can sometimes get confused with that second part of first-degree murder, that second option of first-degree murder of knowingly performing an act that leads to the death, even if the death was not completely intended. Because in felony murder, a felony is being committed, and in the course of that felony, a death occurs. The felony wasn't the murder wasn't the focus. In fact, all indications could be that there was never any intention to actually physically harm someone. Every once in a while, you'll see a case where someone goes into a store, a bodega, a little convenience store, or some establishment, and they intend to rob the establishment, typically with a firearm. And even though they don't fire that firearm, they point it at someone dies, typically a heart attack. Some sort of physical ailment that manifests like a heart attack. And then when that heart attack occurs, and 911's not called, and the ambulance doesn't get there in time, and the clerk at the store, the owner of the store, is being robbed, dies as a result of this heart attack suffered because of the scare, the trauma of having someone pull a gun on them. And having someone pull a weapon on you is not something that is taken lightly by most people. It's traumatic. Because that individual died, the person who was there to rob that establishment can be charged with felony murder. They were trying to commit a felony and somebody died, okay? That's a lot like an act that leads to death, even if the death was not completely intended, so they could be charged with felony murder and first-degree murder. Right? That could be something that the prosecution considers. Now, second-degree murder is not a lesser included offense of first-degree murder. And sometimes confusing, right? Because, well, we have first-degree murder and second-degree murder. Which natural thought processes would say that second is lesser than first, but it is not a lesser included offense of first-degree murder. It's a lesser mitigated offense of first-degree murder. Let me say that again. A lesser mitigated offense of first-degree murder. A conviction of second-degree murder lessens or mitigates. Mitigates means lessens. It reduces the sentence after a person has been found guilty of first-degree murder. It's not an acquittal of first-degree murder, but rather second-degree murder is an acknowledgement that a person may have acted under certain circumstances that society is not prepared to excuse as a complete defense. It's less heinous. It was less intentional. So it allows for a lesser sentence. At the end of the day, there was a killing, an intentional killing. Keyword intentional. Now that's different than the next category, involuntary manslaughter. Involuntary manslaughter in Illinois is an unintentional killing. It results when a person acts recklessly. They act in such a way that their conduct leads to the death of another individual. Now, the difference between involuntary manslaughter and murder and first-degree murder is the mental state that accompanies the act that causes death. First-degree murder requires an intentional or knowing act that creates a strong probability of death or great bodily harm. Involuntary manslaughter requires reckless conduct that is likely to cause death or great bodily harm to an individual. Reckless conduct, okay? Reckless conduct that is likely to cause death or great bodily harm to an individual. Reckless conduct a lot of times when we think of reckless conduct, we think of use of some sort of instrument or a vehicle. And, we have reckless homicide. which is essentially involuntary manslaughter by use of a vehicle. Now, these can all get confused, right? Involuntary manslaughter and reckless homicide are essentially the same things, but keep in mind that when you're charging someone with reckless homicide, they committed a death by way of use of a motor vehicle. A lot of times in those cases, the recklessness was DUI, driving under the influence. Now, as to sentencing and classifications, in Illinois, first-degree murder has its own special classification for sentencing. It's a Class M felony, and it's normally punishable from between 20 to 60 years. However, special enhancements may also apply. Now, remember, I probably shared my my long ago history now when I worked in the Criminal Appeals Division of the Illinois Attorney General's office, helping to continue death penalty cases or defend the state or individual counties and states' attorneys or the cases from the trial level in death penalty cases. Remember, Illinois is not a death penalty state. We do not have the death penalty. But life in prison is a sentencing option. With this or anything else, and you've already had a good opportunity to see this topic, you have to read the entire statute. You can't just read the elements and the sentencing. You have to go on and read the aggravating and mitigating factors. Aggravating means the factors that ramp up potential sentencing. Mitigating, possibly reduce potential sentencing, and how each applies to sentencing or penalties or options for penalties for homicide or anything else. Now remember, and you've seen this time after time, and if you haven't clued in on this, really clue in on it when you look at the aggravating and mitigating factors. Fortunately, a lot of our aggravating and mitigating factors are fairly consistent. We're usually looking at aggravation or mitigation being consistent through the statutes as far as the types of things we're looking at. So in aggravation, it's a category of people that are sought to be protected, or use of weapons in most cases, right? The use of certain types of weapons. Crimes committed with weapons that aggravate and mitigate. When you look at those circumstances, they are also fairly consistent throughout the statutes. Let's move on to our old friend assault and battery. I'm not asking you to find a case for this part of the assignment, but I am going to ask you to go back and do a compare and contrast. In Illinois, assault and battery are two completely different crimes. There is no single crime known as assault and battery. Now, that's not necessarily true depending on where you're located in other states. And in fact, some municipal codes have a municipal offense of assault and battery. I used to hear municipal cases in various Peoria, Pekin, East Peoria, Market Heights, Creve Coeur. I may have heard one in another place here or there. In Pekin, when I heard cases there, they had a practice of anytime people got into fisticuffs over something, they would write them the Pekin City Ordinance offense of assault, battery, and affray. And what that did was the individual would come in and they likely had a criminal case as well in many instances where they're facing criminal charges, but Pekin fined them in municipal court for causing them to have the police come out to essentially a lot of times tell 30 or 40-year-olds they shouldn't act like 10-year-olds. And that was precisely the lecture I would give them. I'd look at them and say, how old are you? Didn't you learn at 10 that you shouldn't be, beating the heck out of somebody because you thought their music was too loud? Or, you got drunk with your neighbor and then decided that they made a comment about your dog that you didn't like or whatever. People just start beating the daylights out of each other. And they would be charged with assault, battery, and affray. But in Illinois, our criminal statutes are two completely different crimes. There is no single crime known as assault and battery. And so you're going to break down the differences. When it comes to assault versus battery, the difference is that assault occurs when a person is threatened or put in fear of getting harmed, hit, touched illegally. A battery is when physical contact with the person actually happens. And the contact has to be harmful or illegal. They're related offenses, but they don't necessarily occur or have to occur together. Now, in most instances, we're going to have potentially an assault and then the battery, especially if people start yapping. But they don't have to occur together. The Illinois criminal charge of battery is listed under 720 ILCS 5/12-3. The law says a person commits battery if he or she knowingly, without legal justification by any means, causes bodily harm to an individual or makes physical contact of an insulting or provoking nature with an individual. You remember my spitting example, right? In the first section of the course. So battery is when someone causes harm, usually by making contact or contact that is insulting or provoking in nature, like a slap across the face. Slap across the face may or may not leave a mark. It probably, just a light slap might get someone's ire or attention, or it may leave a red mark for a minute and it goes away. The essence of the battery is some kind of unwanted physical contact. Now, assault is listed under 720 ILCS 5/12-1, says a person commits an assault when, without legal or lawful authority, not legal authority, it says a specific word was lawful authority, he or she knowingly engages in conduct which places another person in reasonable apprehension of receiving a battery. So they do something that causes the other person to fear, to have reasonable apprehension that they're going to receive some kind of unwanted physical contact. Receiving a battery. An assault occurs when another person is in apprehension of receiving a battery. No actual contact needs to be made for an assault to occur. The essence of an assault is being put in fear of getting hit in a harmful way, or getting touched or harmed in a harmful way. Battery is a Class A misdemeanor. Simple battery in Illinois is a Class A misdemeanor. However, aggravated forms of battery also exist in the code. The battery can be aggravated based on the status of the victim, the place of the or location of the offense, or a variety of other factors similar to the ones we've seen in prior sections of the course, and you will read in that statute. Now, assault, where battery is a Class A misdemeanor, assault is a Class C misdemeanor. A simple assault is a Class C misdemeanor. But there are aggravated forms of assault. Same aggravating factors: status of the victim, the place or the location of the offense, or a variety of other factors related to how assault occurs. Again, see the Illinois aggravated assault statute. Those are the things we're covering in this section of the course, and we move on in the next section of the course to sexual assault, false imprisonment, and kidnapping. So as promised, we had to lay the groundwork, but now we're getting into the nitty-gritty, to the offenses that we see in the cases, to the offenses we see in the newspaper, the offenses that we see in our neighborhoods, in our cities, in our towns, in our counties, and the things that you're going to deal with if you work in law and justice. I hope you enjoy this section of the course. I appreciate your efforts up through this section to the midpoint of the course. Keep your energy up for the second half of the course, please. And if you need me, you know where to find me.